Hello, good morning, good afternoon, good evening. I hope you're all doing well this fine Wednesday. Back with Karen Reid today, and wasn't yesterday absolutely hilarious? Unbelievable. Absolutely unbelievable. Hello, Thunderhorse the cat tracker and professor in mathematics and science. I am waiting for Crash Test Dummy to enter the chat. It's only a matter of time. Hello, Jackie, Two Arctic Wolves, CW and Queen of Ravens, and Amy. Amy loves Karen Reid. And Emmy. Look, it was hilarious. I was crying when I was watching him getting hit at 2 miles per hour. I replayed it about 20 times. It was just so funny. I did a little video on Michelle Walks last night, if anybody's seen it, with an interesting theme tune. That is not the way that engineers are supposed to do experiments. I'm not an engineer. I've never had any engineering training. I don't know anything about engineering, but I am positive that that's not the way that the regular engineering community does experiments. If you're saying that John O'Keefe was collided into by Karen Reid at 24 miles per hour, then you absolutely cannot use an experiment where you hit at 2 miles per hour. The two things do not compute. The two things are not remotely similar at all. It's just crazy town. If this case could get any more weird, well, yesterday it did. It got as weird as I've ever seen in a trial. So, yeah, Ed Wallace, I was thinking about Ed when I was crying with laughter. I was thinking about Ed. I was thinking, oh, his head will have exploded. And he actually said his head exploded. Oh, dear. Yeah, I watched it this morning. Like, they were live, Duty Ron and Ed Wallace were live overnight. My time, I was asleep, but I watched replay this morning, and Ed said exactly what I thought Ed would be doing. Like, it's just nuts. Like, the forensic science community, as well as the engineering community, surely must want to disown the company Aperture at this point. Like, this guy, this Welcher, is the vice president of Aperture. So presumably he's got some, I don't know, sway in the company. He's not just, regular employee. He's the vice president. And surely he has some say in where the company, goes and what the company does, who the company hires and fires. Well, oh dear, Shannon Burgess and Welcher have really, really made Aperture sound like amateur hour. They're just amateurs. Look, some of the stuff, though, he presented was interesting. Well, I'm not going to say that it was all real nonsense. Some of the stuff he said was interesting. Like he admitted there was a little body right at the beginning of the day, which was an hour late. Not really sure what the hour sidebar was about, why they were running so late. But anyway, there was a little VOD, so there was obviously some kind of argument at sidebar of Welcher, and he admitted to Bob Alessi that he had changed his PowerPoint yet again on the advice of Hank Brennan. On Sunday, him and Hank went through the PowerPoint so that Hank could understand everything, because I don't think Hank understands anything, quite honestly. But yeah, on Hank's advice, he changed his PowerPoint again. So he's now going with Shannon Burgess's time of 12:32:04 to 12:32:12, which is when Karen supposedly reversed at 23.9 miles per hour. So according to the data on her car, on her black box, which records trigger events, so anything unusual is classed as a trigger event, and it records 5 seconds before the trigger and 5 seconds after the trigger. How does it record 5 seconds before? It must be recording constantly to be able to then backtrack and record 5 seconds before. Anyhow, I digress. So this 10-second window caught Karen going forward. So this would have been the 5 seconds before, presumably, going forward about 30 feet. And then she slammed the Lexus into reverse, 70% throttle. She was still accelerating when the 10 seconds ended. So we don't know what happened after the 10 seconds because it doesn't record anything further, apparently. So at the end of the 10 seconds, she was going at 23.9 miles per hour, but there was no braking. So she was still in that maneuver, and that was 53 feet. So she reversed 53 feet. She may have reversed further, but because the Lexus stops recording after the 10 seconds, like the 5 seconds before and 5 seconds after, then we don't know what happened after that. She must have braked at some point, or else she'd have ended up on Cedar Crest. But the point at which that maneuver started, so the trigger was her slamming the vehicle into reverse and going at 70% throttle. That was the trigger event. So that happened, according to Burgess, between 12:32:04 and 12:32:12. So if you do the math, right, and you do how long does it take to travel 53 feet whilst accelerating to 24 miles per hour, providing that your acceleration is consistent, then it will take you 3 seconds. AI told me that, right? AI told me that last night. So 3 seconds, right? So if we went 3 seconds from 12:32:04, it would take us to 12:32:07. Well, John is well away by that point, as I talked about the other day when I reviewed Burgess's testimony. It's absolutely nonsense. There's absolutely no way Karen Reid could have hit John O'Keefe. I'll show you again. I'll show you for why. Hold on 1 second. I'll just screenshot this and then I don't have to go out and come in again. I'll show you for why. It's obvious. Absolutely obvious. If you can't see this, I just don't know what to tell you. Hold on. All right. Okay. Let's show you this. This is a little timeline I put together. This is just a little timeline I put together. All right. So the thing that Hank Brennan doesn't want anyone to remember is that John O'Keefe's phone was active throughout this entire time. But Hank doesn't want you to remember that John O'Keefe's phone started walking at 12:31 and 56 seconds. John's phone begins walking and carries on walking for an entire 20 seconds until 12:32 and 16 seconds. Within that 20 seconds, he walks 36 steps and 83 feet. At 12:32:09, which is when the phone locks, but he's in transit at this point. He is walking at this point. So by 12:32:16, he's walked 83, or at least his phone has, and as far as I know, iPhones can't walk, as far as I know. Anyhow, certainly mine can't. Maybe John's could. Maybe he had an app or something that allowed his phone to walk on its own. But he was checking his text, and then he, I don't know what he did, locked his phone, and then he carried on walking. Meanwhile, between 12:32:04 and 12:32:12, Karen did this mad reverse maneuver, according to her black box, right? So if this event began at 12:32:04 and lasted for 3 seconds, like 53 yards at an acceleration 24 miles per hour, takes 3 seconds. So that's 12:32:07. Well, that is a whole 11 seconds. That's a whole 11 seconds after John O'Keefe's phone started walking. So John has walked, if you take 8 seconds, John, that's 33 feet. So he's 33 feet away from Karen's car, presumably going at a westerly direction to go into 34 Fairview. And if, let's say, the trigger event started here, because it could be anywhere between here. Let's say it started at 12:32:12. Well, John, by this point, would have been almost to the house. So it doesn't make sense. The timeline from John's Apple Health data and his phone does not make sense if you're trying to meander some kind of narrative that Karen hit him when she reversed. Doesn't make sense. I'm sorry, it does not make sense. Why has my thing gone like that? There we go. It does not make sense. That's all I need to know. If the timeline does not make sense, that's it, that's all. That's it, that's all. And this is data that's like actually backed up somewhere, and the evidence has been presented by the Commonwealth's own witnesses. This is exactly the same as happened in the Delphi case, that the timeline that the state proposed did not make sense in relation to the state's own data that their experts presented at the trial. If the timeline doesn't work, I'm sorry, that's it, gone. Your theory's gone. Think of something else. All right. Anyhow, so we went through all that data again with Welcher. then he got into his engineering stuff, you know, his experiments. So we're gonna play his fantastic experiment in a minute, just to have a laugh. But the really serious part of the day came right at the end, and we're going to play the end first because it got really, really serious at the end. And in my opinion, this is enough to warrant a mistrial. I don't know whether the defence will call for a mistrial, just to put it on record. I'm sure Bev wouldn't grant it. But Bev has had to go away and sleep on this problem. So if you stayed till the end of the day, things got bad right at the end of the day. Definitely can't do math. How long does it take to accelerate? I'm really lost. All right. Before we play this, let me show you what I did. If I've still got the conversation with ChatGPT. All right. Okay. So I asked ChatGPT, like AI, you know, because we're all just like brain dead, aren't we, at this point? We can't do anything for ourselves. We have to ask AI. But step by step, for calculating how long it would take a vehicle to travel 53 feet, which is what Welcher testified to, that she reversed 53 feet. And during that time, she was accelerating. And by the time that there was that cutoff, by the time it stopped recording, she was traveling at 23.9 feet, 23.9 miles per hour. I just called it 24 just to round it up. So if you've got the distance you traveled and you've got the speed, whether it's an exact speed or whether it's an acceleration, you can calculate how far you've traveled. How long it's taken you. All right. So, okay. So you've just got to ignore the math. So it says it would take approximately 3 seconds for a 2021 Lexus SUV to travel, to reach 24 miles per hour over 53 feet, assuming constant acceleration from rest. Because it has to assume that you accelerated at the same rate for those whole 3 seconds. You know, like you could have started off slow and then just floored it in the last second. That wouldn't be constant acceleration. So you do have to assume that the acceleration's constant. But she was accelerating because there was no brake activity recorded. However, it's a theoretical minimum. Theoretical minimum. Actual performance could vary based on a specific SUV model and throttle response. Most Lexus SUVs can accelerate 0 to 60 in 6.8 seconds. So this estimate is within a realistic range for lower speed acceleration. Now, Karen's was the LX570, I think. And that's like a big model Lexus. Right, it's got a big engine. So I think that's going to, I don't know anything about cars. I think that's going to make a difference. But let's just say 3 seconds. And might be 2 seconds, might be 4 seconds. But the point is, it really wouldn't take very long at all to travel 53 feet if you were going at 24 miles per hour. At least for, you know, you're accelerating to 24 miles per hour. So it occur in any time that acceleration, that time traveled, that distance traveled, whatever you want to call it, happened between 12:32:04 and 12:32:12, whichever time it happened, whether it happened here, whether it happened here, you still have to factor in John's phone. And John's phone was walking. John's phone was walking until 12:32 and 16 seconds. How can it be? How could it be? Because if the reversing started here, he's almost at the house. Yeah, she had to brake to go forward. No, it wouldn't record that. Buttercup baby, it only recorded 10 seconds. It records 5 seconds before the trigger event and 5 seconds after. So all I'm talking about is the reverse maneuver. So of course you would have had to brake, or else she'd just be in reverse forever. Of course you would have had to brake, but it wasn't recorded because the 10 seconds was up. So it is confusing, but that's what we're dealing with. All right, let's listen to this. So this is right at the end of the day. And this, I think, was going to be Hank Brennan's crescendo for the day. This was going to be his ha-ha, gotcha moment. The jury were going to take away and everything that Hank had been working up to for the entire day. Now, the entire day was kind of ruined because it was started late. There was lots of sidebars. There was some long sidebars. Bev was sustaining a bunch of objections because this guy, like, either Hank was asking him really leading questions or this guy was going beyond his expertise. So, and right at the end, this was absolutely terrible that this happened. And again, this surely is grounds for a mistrial. However, I don't think Bev would go for it. I don't think so. Even if the defence wanted it. Now, the defence might call for it, knowing that Bev wouldn't deny it. They might call for it just to put it on the record for, appeals reasons, for appeals purposes. But anyway, we're going to play from here. I'm going to play to the end.
Based on your analysis, data available, reviews, study, based on the fact that you are an accident reconstructionist and a biomedical engineer, have you reached an opinion to a reasonable degree of engineering certainty whether...
That drove me mad the entire day. Reasonable degree of engineering certainty. There was nothing that this guy testified to. There was actual engineering. What did he testify to that was engineering? Because the experiment that I guess you would say is some kind of biomedical experiment was nonsense, as we'll see when I break it down. So I'm not sure that he did anything that could be called engineering the entire day.
The defendant's Lexus struck Mr. John O'Keefe on January 29, 2022, around 12:32 a.m.
Yes.
And could you share the bases of your opinion?
Bases is not a word, Hank. It's bases. If you want to make the plural of basis, it's bases. Just so you know for next time.
And before I ask you your ultimate opinion.
Sure. So again, you've seen my slide presentation. I've inspected the Lexus. I've looked at where it wasn't damaged. I've inspected the taillight. I got an exemplar Lexus. I ran lower speed contacts to verify that the injury pattern and location on the arm is consistent with the height and orientation of the taillight.
But you missed a whole bunch of stuff and you made a whole bunch of assumptions. but we'll get there.
I have looked at fracture tolerance data for falling backwards onto hard surfaces. I've looked at the metrics of where his injuries were and what injuries he didn't sustain. I've looked at the cell phone data, and then I've looked at Miss Reed's interviews as well.
Based on all the evidence you considered, could you?
Miss Reed's interviews, they're not relevant to your assessment. You're a biomedical engineer or biomechanical engineer, whatever you call yourself. Nothing else in the case is relevant.
You share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m. I can answer.
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
DNA! Where in his entire testimony did he mention DNA? Now, we've had DNA results, but we know that the DNA results are actually not very convincing at all. So, no, you can't say that. Can't say that. You can't say this is what happened. Can't say that. What did he testify to that was reasonable? I thought the stuff to do with the black box, where he was reading the ones and the twos and the zeros, I thought that was reasonable. That's actual data that you can get from the Lexus. So testifying that into the record, I didn't have a problem with. So that was okay. Not engineering, though.
She moved to strike your
So I'm gonna strike that. I'm gonna see counsel's have up just.
Oh, Bev was very quick to strike that. Bev knew. He is a bullshitter for money. I think the entire company, Aperture, is its entire ethos and ethics have been brought into question based on the two experts that have testified at this trial. Like right at the beginning, he said, "Oh, I've got no dog in the fight or horse in the race," whichever analogy he used. But yes, of course he does. Of course he does. The fact that he was prepared to change his entire presentation based on Hank Brennan's advice at the 11th hour, yet again, like this is trial by ambush. This is exactly what Hank was saying the defense were going to do to him. He has done it to them, and he's done it to them again. He's done it to them again by changing his presentation on Sunday during the weekend. Just this Sunday just gone. Changed his presentation to suit Hank so that Hank could tell a better story. Now, if that isn't bullshitting for money, I don't know what is. I really don't know what is. Yeah, fancy having your star witnesses conclusions stricken from the record. Oh, dear, yeah. Yeah. Exactly. 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 Yeah, it's not difficult stuff. It's the way it's being presented that makes it difficult. Like, you have to strip away all of the irrelevant stuff. There's a lot of data being presented that isn't relevant. It's the way the questions are being asked. It's being made to sound way more technical than it actually is. And they're trying to wow the jury with impressive sounding testimony, when actually, when you strip it all away, there's not a great deal to it at all. So my concern, and I've voiced this concern before, my concern is that the jurors who don't understand it, the jurors whose eyes have all just glazed over, they're not going to listen or try to understand. They'll just switch off and they'll say, well, it sounds good, it sounds important, this guy's an expert, I'm going to believe what he says. And they're just going to go with it without any further thought. The ones that really do think it through, the ones that understand it and work it out, well, they're the ones who'll say, this doesn't make sense. This absolutely does not make sense. But it depends on whose voices are the strongest during the deliberations. If you've only got one person who really understands it, they might not be enough to be able to persuade the others who didn't really understand it, but think, well, he's an expert and I believe him. Might not be enough. And it depends whether that one person decides eventually to acquiesce and go, oh, well, sod it, I just want to go home. If not, then it'll be another hung jury. And I can't see anybody wanting that. I can't see, the prosecution obviously won't want that, but I can't see the defense wanting it either. Because second trials for the defense is always harder. Like the prosecution has an advantage in the second trial of any second trial because they know the defense, tactics. So if there was yet another mistrial and the Commonwealth decided to try her yet again for a third time, it'd be even harder for the defense. So I've got really big concerns that Hank's going to win based on this technological mumbo jumbo that the jury really didn't understand. Bev can remedy this by throwing out his entire testimony. She absolutely can. But the thing is, the jury have already heard it. Like, you can't put the genie back in the bottle. They might not be allowed to discuss it during deliberations, but it doesn't mean to say that it won't have had an effect on their opinion. And again, it'll be down to those jurors who really stick by the book and say, really firm with the others and say, no, that none of that is relevant. None of that is relevant. You're putting a lot on the jurors. You really are. And when you put a lot on them, when they've got a really heavy burden, then it's risky. All right, this is I forget how long this sidebar is.
Yeah.
All right. So for those that turned off here, you missed some. This is bad.
All right.
Dr. Welcher leave?
Dr. Welcher can step down. I know he has to come back and have his
So
equipment.
just leave everything here.
And then you'll come back in 5 minutes.
Roger.
All right. Yes, please. All right. So, Mr. Alessi, I will hear you as to your objection.
Is Cassie dreaming? Yes, she is. Can't ring the bell exactly.
Thank you, Your Honor. Would you like me to go to the podium or stand?
Right there's fine. And let's try and wrap this all up by 4 because I've already heard you at sidebar.
She can't stay past 4. It doesn't matter how serious the things get. Bev will not work past 4 p.m. I don't know what does she have a long drive to get home, or does she have someone she's caring for that she has to I don't know why she can't work past 4 p.m. especially that they only started the testimony like mid-morning. The least you can do is let them have a good debate here. Well, she rushed them, but she rushed them both, to be fair. She rushed them both.
We'll do something, all right?
That means both of you I'll hear from within the next 5 minutes. Go ahead, Mr. Leslie.
Thank you, Your Honor. The point number one is the question of whether, based on reasonable degree of scientific or certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time equivalent. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury. That is why we are having this trial. The defense strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the two questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle?
Exactly. That's it. That's all. That's what a biomechanical engineer could testify to. Is the damage to the vehicle consistent with a collision? Is the damage to the pedestrian consistent with colliding with this particular vehicle at this particular speed? That's it. That's an engineering problem that can be worked out, or at least can be testified to. Not using silly experiments with blue paint, however, oh my God.
Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So what Mr. Lisi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was no collision, over and over and over again. And he just told you that when his expert takes the stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder.
No, it isn't. No, Hank. That is not the purpose of this trial. The purpose of this trial is not to determine whether it's murder or whether it's manslaughter. The purpose of this trial, Hank, for your information, is to determine whether or not Karen Reid is guilty of any of those charges. So you're comparing it not between one charge and another charge. You know, it's not just either or. It's, did Karen do this? And if no, did Karen do this? And they can say no, not guilty of anything, or it's not an either or. That's complete and utter. If Hank truly believed that statement, then I'm sorry, how on earth is he a lawyer? Most to the point, he's actually a defense lawyer. How does he work if that's what he goes from? If that's his standard that he works from? Unbelievable.
Not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car.
That's obvious. Well, that's for the jury to decide, not you. Not you.
Or Alexis, that evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist. He studied the tech stream data. They didn't, he did. And he's entitled to give an opinion. The tech stream data, based on fact and science and data, tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't.
What about John's Apple Health data? You don't want to talk about that, do you? No, okay.
Have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her.
He didn't do any engineering. And the stuff that he was going to say until he was stopped would be nothing to do with his expertise, nothing to do with his engineering expertise, none of which I've seen in this testimony. The guy might be an expert, the guy might be a genius, but I just haven't seen it in this testimony. Sorry.
Her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the tech stream data, the physical evidence, his independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe. And he's also allowed to answer, in his opinion, the issue of a collision, putting aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify. It's not our fault that ARCA didn't testify or look into the tech stream data, or they don't have an expert for it. It doesn't belittle or limit that evidence. We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022, around 12:32 a.m. That is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence, or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you
I
looking
will
at?
also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between a clip or a side swipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper. And there are further slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
Consistency with a side swipe or a clip.
okay, so this is not the end of Dr. Welcher's testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, go to case law, here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands as a proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCA report right in front of me. And I have the report.
Is that a new one or is that a?
This is the new one.
Okay.
It's also, the old one is the same. So I can, either one is the same. They do not, Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that, because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision or conclusion. It's consistency. So there's two questions I said in sidebar. And for reference, Your Honor, for the most recent is page 15. There is no.
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also.
How does she not have the ARCA report? How does she not have it? Was she not in the like there at the last trial?
Your Honor, refer Your Honor to ARCA's existing report, which I'm going to do from memory. I think it's February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you with sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
All right. So we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today. All right.
What do you mean? She sat through the entire day. Surely she knew what came into evidence. I know it got really confusing because they had to stop and send the jury out to sort out what slides they were all looking at. Like, they seemed to have different versions. I'm not really sure what was going on. But at one point, Hank and Bob Alessi were with Dr. Welsher. I think people had different versions, so they weren't following along. I'm not really sure. It begs the question, how many times has this slide presentation changed? So I can't, honestly. So the jury are only coming in at 10. So I don't know whether we're all going to start at 10. So this discussion is going to start at 10, and then the jury are going to be hanging around, or whether they're going to come in for 9 and the jury is starting at 10. I don't know. I don't know. So be prepared for more long waiting today. But there's still some more, assuming that she just, you know, brushes this under the rug and says, oh, it's all fine. Just be careful. You know, just be careful what you say. You can't say this and you can't say this. And then she brushes everything else under the rug. And assuming that Welcher gets the go-ahead to finish, then there's a little bit more of the direct. And then there's going to be an almighty cross-examination. I cannot wait for the cross-examination. Cannot wait. She was busy colouring in. Yeah, she probably has like a colouring book or something. You know, those books for adults, colouring books for adults. Like stress relievers. She probably has that. She probably does crosswords as well. She probably sits there doing a crossword. She's starting at 10 and will make the jury wait. That's what it sounded like to me. But I'm just kind of living in hope that one day, maybe, she'll start on time and actually do a full day's work. Maybe just one day. Just one day. I don't know. Maybe she has health issues. I don't know how she gets away with it. All right. Okay. Now, let's take a look at this engineering mastermind at work. Dear God. Dear God. All right.
So the impact, which you'll see in a second, even at 2 miles an hour, will induce rotation of the body. So depending on the speed, the higher the speed, the more rotation. So
I can't. You can make your own mind up as to whether he rotated himself. I'm quite sure that he could have jumped the other way, jumped like backwards, like and not done a rotation. I'm actually quite convinced that he rotated himself. But how will we ever know? And they actually filmed it from 3 different angles because they thought it was that good. You know, when you set up multiple cameras, that you know it's going to be good. Dear me.
if I may, so slide 111, this is simply showing where I walk sideways, how this lines up with the location of the lacerations on Mr. O'Keefe's arm. Here's the post-contact stuffing up.
For those who didn't see it, what they did, this is a Lexus, same model, same year as Karen's. They bought this Lexus, right? Aperture bought this Lexus. I assume, actually, the Commonwealth of Massachusetts bought this Lexus, but this is grease paint. So they covered the taillight in grease paint, and he basically put his arm on it. This was his first test. He basically put his arm on it to show that the paint would go in approximately the same place as John O'Keefe's injuries on his arm, which is why you've got John O'Keefe's arm there in the corner. But he just placed his arm. It's like, well, you could just place your arm in a different way. It doesn't mean to say John O'Keefe had his arm like that. It's just stupid. It's just really stupid. And it's a really like artificial way of holding your arm. Like if he's walking along, you're not having your arm like bent like he had.
taillight. Here's a picture of Miss Reed's vehicle on the right-hand side. So now I said, okay, that was me walking into the car.
All right, so that's him walking into the car. Now they're going to have the car walking into him. So he dressed in the clothes that John O'Keefe was wearing, not the literal clothes, but he got the same jeans, the same shoes, the same T-shirt. He had the same top on, but he took the top off for this experiment. Why did he take the top off for this experiment? Presumably because he didn't want to get paint on the top and he wanted the paint to be on his arm to show the positioning on the arm. But later on, when he's done this experiment, he's explaining this to the jury, he brings up the injuries or the damage to the hoodie that John was wearing. And it's not consistent at all with a shattered taillight. This is the kind of stupid stunt I'd do, right? But even I would not do this. I wouldn't get Kyle to back into me at 2 miles per hour to show that I could get paint on my arm in the same place that John O'Keefe's injuries were at. The reason why I wouldn't do it is not because it's somewhat foolhardy, that Kyle might just put his foot down accidentally. Is because the reason why I wouldn't do it is because it's completely irrelevant. Because going at 2 miles per hour is not the same in any which way in anybody's universe. It's not the same as being backed into at 24 miles per hour. Surely everybody would realize that this is just complete nonsense. So he's got these same clothes, even the same hat. Now I can actually understand him maybe wearing the same shoes, that you're exactly at the same height. And he was, I think he's half an inch shorter than John and maybe a couple of pounds heavier, but he's approximately the same size. So he's using himself as basically a crash test dummy. So crash test dummy really did enter the chat yesterday afternoon. This was crazy. But I could understand him wearing the same shoes. I don't really understand why he needed to buy the identical clothing. I suppose it's so that, somebody can't come along and say, well, you were wearing different clothes and somehow that made a difference. I don't know. But that's why he's dressed up as John O'Keefe.
Let's have the car drive into me. I did this at very low speeds. And you'll see, and we'll throw this from 2 different angles. That's me showing.
No, they had 3 different angles.
I'm doing test 2. This is from a camera that we have pointing down at it. This is the speed. You'll see it's only about a 2 mile an hour impact. But even a 2 mile an hour impact redirects me back and causes me to rotate and take a step.
Look how he's standing. I want you to notice how he's standing. There's a sidebar in a minute because he goes to the driver and then, anyway, I'll just fast forward because there's a sidebar. But he comes back and does this experiment again.
In no way were you trying to imitate or give a demonstration of what you...
He went to chat to the driver to tell the driver what to do. Like, 2, no faster than 2. I assume that's what he was saying. I don't know what he was saying. I wasn't there.
Believed Mr. O'Keefe's movements to be.
Oh, no. This speed's just 2 miles an hour. I was having a discussion with the driver about what we needed to do to conduct the test.
So when you walked up to the passenger side, it wasn't to replicate a study or a movement or given a...
No, that walking had nothing to do with this case except for me instructing the driver what to do.
Thank you for that clarification.
Sorry about that.
No apology necessary. Could you go back to the beginning when you were explaining this so we can go through it?
So this is the dynamic test 2.
God knows what John O'Keefe's family think about this. Like, I'd be a little bit fuming. If I was a member of his family, I'd be a little bit fuming of all of this nonsense. But they believe in the Commonwealth, so what can you do?
So again, this is the view from behind.
Right, right. Look how he's standing. He's positioned himself in a way, right, that will force his body round a corner.
And just to avoid the confusion, I will start it here.
What speed is the car traveling?
Like the way that he's standing. The way that he's standing sends his body in a corner, round a corner. If he had his feet positioned the opposite way, he would not have rotated like that. I wonder how many times they did this. I wonder how many edits this took. I wonder how many different positions he put himself in before he got this footage. He absolutely leans into it. He absolutely leans into it, and I'll prove it to you. I'll prove it to you by showing you my video that I did last night on Michelle Walks. Because yes, it was meant to be funny. Yes, of course, it was meant to be funny. But hold on. All right. Yes, it was meant to be funny. However, there's a serious side to it. So I'll play it. I'll play it the first time with the tune. And then I'll play it with the sound off and show you exactly why this guy has engineered, pardon the pun, he's engineered this situation.
All around the mulberry bush, the monkey chased the weasel. The monkey thought it was all in good fun. Pop goes the weasel. A penny for a spool of thread, a tuppence for a needle. That's the way the money goes. Pop goes the weasel. The monkey chased the weasel. The monkey thought it was all in good fun. Pop goes the weasel. A penny for a spool of thread, a tuppence for a needle. That's the way the money goes. Pop goes the weasel.
Honest to God. Honest to God. He rolls into it. He absolutely rolls into it. He absolutely does. He absolutely rolls into it. All right, now I've got this video up. I'll turn the sound off. I'm going to have to play 5 seconds of this ad before I can get back to it. All right, okay. All right, the reason why I've slowed this down is because you see exactly what he does. Now, it's not as obvious with this one that he played first. It's not quite as obvious. You only see it when you look from above. And then there's a third angle that they didn't concentrate on. You could see that third angle in the corner when he played the above one, but he didn't mention it. But that one, I think, is the most telling. So you don't really tell from this angle that he rolled himself into it. You kind of see him positioning, that he's watching his positioning exactly, and he rolls round to make sure the paint goes on the upper arm. Watch him. So the connection there, he rolls his shoulder down so that he makes sure that this gets the connection. But you can see it dead clear on this. Watch him lean into it. He leans before the connection. He leans before the connection. He leans before that car even touches him. Dear God. The trouble is, though, the jury have only been able to see this once, or maybe twice they played it. Now, whether they'll have this video in the deliberation room and whether they're going to be able to manipulate it like I've done, like slow it down or whatever, I don't know. I don't know what the rules are there. When I was a juror, 2020, they had a whole bunch of CCTV footage, a whole load of it. And what they did, they gave us a laptop with the CCTV on, and we could play it in the deliberation room as often as we wanted. What you couldn't do, though, was zoom it in. You couldn't do anything. You couldn't manipulate it. You couldn't edit it. You couldn't do anything. It was just as it played in the court. So whether they'll be able to do that and they'll have to keep stopping, starting. I don't know. I don't know whether they'll have, obviously it's in evidence, but I don't know whether they get all the videos and everything. But this is the angle that was in the corner when he played the overhead one. So I've just blown this up. And this one, it's so obvious. He leans into this before there's any connection. Watch this. Look. He rolls around the car. That's unbelievable. The car hasn't even connected with his arm before he starts rolling. It's just so stupid. How many times did they do this to get it right? I wonder how many edits they did. How many different times they did it. He rolls around. That car is hardly moving and he rolls around it. Absolutely insane. Insane that has been allowed into evidence. I hope that Alessi goes mental at him. I hope Alessi rips him a new one. All right. Now, after the experiment, this got even, like, I started to really, like, I was laughing. I was like crying with laughter. There was literal tears. I played it about 20 times and then I got serious and I started to listen to where he said all the points on the Lexus that showed damage and the places on John's body that would have connected. And this is crazy. When you keep in your head that the vehicle was going at 24 miles per hour. Because he even claims that the injury to John's eye, the scratch on John's eye, was caused by the Lexus. Now, if you had your head connect with a vehicle that weighs 6,000 pounds and is going at 24 miles per hour and it connects with your eyelid, do you think you're going to get a minor scratch or do you think it's going to cave the front of your head in? It's an open question. However, this is exactly what he tried to say. So I'm going to play this. It's a few minutes where he talks through and he's got all these diagrams and it looks dead impressive. All right, you know, you've got him there dressed as John with his paint on and it's showing where it's connected. It's showing where it's connected after he rolls around at 2 miles per hour. Like, why did they not get a life-size crash test dummy that's like weighted to see how that moves. Surely that would have been more realistic. Not that it would be, because it wouldn't move exactly the same way that a human body would. But it's just beyond any form of logic at this point. But anyway, let's play this few minutes.
Dr. Welcher, do you have any indication of how Mr. O'Keefe's arm was bent, what angle it was bent at?
Not exactly, but for these to be taillight shard fragments, they would need to be in the area of the taillight, but it could be further up. We know from the police photographs that there was a damage to the rear body panel in the area I'm searching here. So it's possible his arm was a little higher up and the glass hit the rear of the Lexus and caused that damage.
In the bottom right.
So the glass hit the Lexus and caused the damage. Okay. So where was the glass when he did his experiment? Because he bought glass. He couldn't get a glass exactly the same as what they had in the waterfall. The glass didn't actually come from the waterfall. The glass, if you listen to Karen's statements, the glass actually came from McCarthy's. And Karen brought it over to the waterfall from McCarthy's, and she just kept adding drinks to that one glass. And then John walked out with it. So if he wanted an actual glass, why did he not just go to McCarthy's and say, can I buy a glass of you? I don't know. Why he would need to, because he did nothing with the glass that we saw anywhere. Maybe it's because he couldn't get an experiment to match what he thought the glass did. Who knows?
Your objection is
I will strike that last part about the glass.
Thank you.
The purpose of the circle is for what, Dr. Welcher?
To show, in this case, primarily the location of the lacerations up on the arm, the upper part of the arm, and that they match up with the locations of at least the one remaining shard in the rear taillight of Miss Reed's Lexus.
What do you mean, one remaining shard? So if by the time the arm connects, there's only one remaining shard left, well, when did the tail light break then? Because wasn't the arm meant to be the thing that did the damage? So you can't say that a certain injury on John's arm matched up with the one remaining shard, because surely you've got to match the breaking of the tail light. Because didn't the breaking of the tail light happen at impact? You can't have it both ways. You can't have the arm causing the impact and therefore 47 pieces flying everywhere, and then say there was one remaining shard, because surely the injuries had to happen when the impact happened. Absolutely illogical.
Looking at the picture of the Lexus, bottom right middle, are there any marks on the Lexus itself that you took note of?
Yes, it's on the next slide.
Thank you.
Actually, it's 2 slides. So there, again, this is the evidence marker. There was a horizontal scuff. We know.
And that could have been caused by when she bumped into John O'Keefe's car at One Meadows. How do we know that scuff wasn't there beforehand? How do we know that scuff hadn't been there for 6 months or a month or whatever? It's very easy to scuff your car. How do we know that scuff wasn't already there? And an impact at 24 miles per hour, is it really going to cause a little scuff? Because listen to where he says this connects, supposedly, with John's body.
Mr. O'Keefe had blue jean type pants on. There's a scuff in the area that would approximately correspond to hip level.
There's a scuff at hip level on his jeans. So he's now saying that this scuff was caused by John O'Keefe's hip impacting with this lower part of the vehicle. So now we've not just got an impact at the right arm, we've got an impact at the hip that caused a scuff mark on the jeans to correspond with the height of this scuff mark. Well, how come then, because remember, this collision was at 24 miles per hour, how come there's not even a bruise on John's hip? How come there is not one bruise, nothing on John's hip? Like, was John wearing, like, I don't know, protective clothing or something underneath his jeans? Come on now. No way. No way. Absolutely no way.
For Mr. O'Keefe.
And next slide, please.
Yes, ma'am. 118.
Thank you.
Exactly. Like, hips are quite bony, aren't they? Even if you've got a little bit of meat on you like I do, hips are quite bony. So if you knock your hip, you get a bruise. I mean, I remember whacked it on a door frame approximately 0.5 miles per hour. Bruise. Oh my God. I remember once, right, at work, and a student asked a question. And instead of just walking around, right, instead of just walking around the desk, I tried to jump the desk and completely, absolutely, completely and totally missed my footing, fell against the corner of the desk onto my hip, and I had a huge bruise. It was huge. And that was literally me misjudging a jump and just basically knocking into the desk. So if a vehicle hits you in the hip at 24 miles per hour, you are going to get injured. Listen, my mother, I'll tell you a story. My mother got hit by a bus. She got hit by a bus, right? So there's a zebra crossing at the top of the road, right? So where my mum lives, to get to the, I don't know where she was going, but she was crossing the main road, and there's a zebra crossing. And she was running. Well, she wasn't running, but she was in a hurry. To wherever she was going, she was in a hurry. And there was a bus coming, and she said she saw the bus coming. The bus slowed right down because there's a zebra crossing. But somehow she ended up on the zebra crossing, and the bus didn't stop. So the bus must have been going at, I don't know, probably 5 miles an hour. The bus was going mega slow, because not only does the bus have to slow for the zebra crossing, but there's also a bus stop very close to this zebra crossing. So buses always slow down at that point. Even if there's no one waiting at the zebra, if there's someone at the bus stop, the bus is already slowing down. So the bus was going really slow, and she ended up getting hit by the bus, and she fell onto her hip. Like, the connection was at the, I don't know where on the body it got her, but it must have been like to the side. And she fell to the side, and she had bruising all down like a side where it connected with the bus. But she fell onto her hip, and she had really, really bad hip pain for months and months and months. She got bursitis, which is inflammation of the bursa, I don't know, membranes and shit. So that was a collision. It must have been 5 miles an hour, if not less. So any connection with a hip, it's going to send you off balance. It's not going to just roll you around like they're trying to say. It'll send you flat on your side or wherever. It'll knock you in the complete opposite direction. So if his hip had connected, it would be bruised. He'd probably have broken. He would have fallen right there, and he would have had injuries to his hips. There's nothing. There's no way. No, absolutely zero way. Zero way. I remember my dad rang me, right? My dad rang me and went, "Your mother's been hit by a bus." It's like, you what? You what? Is she dead? What? He's like, "Oh no, she's all right. I'm just going to go and see her now." It's like, what are you doing? Oh dear God. All right.
Did you describe what you saw on the bottom right-hand corner photo as well?
I believe, yes, I did. That's the scuff that lines up with the approximate height of Mr. O'Keefe's right hip.
Dear God.
So then I included previous image that you've seen, slide 119, with the reconstructed photograph of the rear taillight, showing where some of the fragments are. You can see where those fragments are relative to the curvature of the taillight. They'd be in the area somewhat centered within the region of the two yellow lines on slide 119.
Is there anything about the photograph in the top right-hand corner that's important? If so, could you zoom in and show us?
So again, it's showing that this is when it's, I believe, in the Sally Port at the police station, showing that scuff on the right rear body panel.
Did you see any similar scuffs in the middle back of the car?
Objection, Your Honor.
Sustained.
Did you see anything notable as far as damage to the middle back of this Lexus?
The middle,
Yes,
like back where the doors are,
but with the middle of the back of the car, did you see any similar damage to the middle?
there
or the
were
left?
scuff marks that ran along the bumper.
So again, that could have been caused when she connected with John's car at One Meadow.
Okay, continue, please.
So this is just showing his jacket he was wearing, that the,
All right. So the jacket, if you go back and look at the jacket and the marks on the jacket were puncture wounds. If John O'Keefe's arm had connected at the lower arm like he did, like, and rolled around, right, how it would have broken the taillight, I'm not really sure, but rolled around and the taillight was all like spiky and shardy, why would there not be huge rips in this fabric? Because it would have had to go through the fabric to make marks on his arm. So why is there not like it would have shredded the material, surely? It would have shredded it in all the places where, because the taillight pieces, like, it's plastic, it's hard, and it's going to be like sharp at the edges, isn't it? So how come these are not like shredded in all the locations where there's these marks? Why are these puncture wounds that look exactly as would be caused by dog's teeth or dog's claws getting caught in the fabric? So that doesn't make sense at all.
puncture marks coincide to the marks on his arm.
Because the car is moving at 24 miles per hour and the body's also moving. So it's going to get caught. Surely as it rolls around like he did, like the shards are going to get caught in the holes. There's going to be shards in the holes. So why was there no shards of plastic in the holes? Like, no, this did not happen. You'd be able to match up the damage on the hoodie with the damage on the taillight. I'm quite sure if it really happened the way he's saying, like with him connecting and smashing the taillight and then rolling around, you'd be able to show that damage on the hoodie. No, didn't happen.
This is from the autopsy report. A couple things it notes: a 0.5 centimeter abrasion on his right lateral knee. He's got a laceration on his right eyelid. That corresponds to the height of that thin rear wind wing on the back.
Come on. No. So a tiny laceration on his right eye that might be caused by a punch. Someone punches you and the top of your eyelid, you've got that bone, right? The top of your eyelid. So someone punches you in your eye. It's very common to get either a cut on your eyelid itself because the skin's thin, or on that bony area. You don't have to punch someone hard to make that happen. right? Believe me, I used to do martial arts, right? And it bleeds like you wouldn't believe. Like a tiny, tiny cut on your eyelid or the top of your eye bleeds like insane things. So there's no way that a tiny, tiny cut would be caused by your head connecting with a vehicle that was traveling at 24 miles per hour. It would have sliced your head open. You'd be able to see your skull, depending on like where it connected on, kind of like that little wing thing that juts out. That's what he's trying to say. Your head will be sliced open. It wouldn't be a tiny, tiny cut. This is just, it's just stupid. Surely he's listening to himself talking and realizing how stupid this sounds. Is this what Hank Brennan paid him for? Is this what Hank Brennan told him to say when they met on Sunday? Surely he can't believe the words that are coming out of his mouth right now. Good God.
Back of the Lexus.
Remember to object.
Sustain.
Thank you.
How tall was Mr. O'Keefe?
73 inches tall, 6'1".
And how high was that wing from the ground on the back of the Lexus?
It was about it's about 5 feet 11 inches, maybe 5 feet 10 and a half.
So, okay, so John's eye is only 2 inches from the top of his head. 3 inches. All right, okay, maybe. Your eyes are quite high, aren't they? But come on now. So we've got the right arm that connects and then rolls around to send him into a pirouette. We've got a scuff that connects, that shows a connect with John's hip. And then we've also got the laceration on his right eye, which shows that it connected with the top of the wing. No. I'm sorry, no. I want to see this guy do it. Even at 2 miles an hour. Right? Stand there. Don't roll around silly. Just stand there and show how that place down at the bottom of the bumper would connect with your hip, and show where that wing would connect with your eye. Because I bet you any money, even at 2 miles per hour, you would have a God Almighty bruise on your head, a God Almighty headache, probably a concussion. You're not going to feel very well. Let's put it that way, even at 2 miles per hour. Don't do it, anybody, because you don't need to show this. If I even thought that this could have happened, do you not think that I would have done this experiment already? Do you not think that I would have got somebody like, because I'm only 5'5", so I'd need a slightly smaller car so that, you know, my arm would connect with the same place and blah, blah, blah. All right, Kyle's cop, maybe. But do you not think I would have done it already? Do you not think I would have been stupid enough to film something like that? If I thought it would have shown a point that actually made sense, I would have done it already. Nobody in the right mind would do it at 24 miles per hour because you know it's going to cause serious injuries. But the thing is, it didn't cause serious injuries. The connection with this vehicle, supposedly, didn't cause any serious injuries to John at all. Completely inconsistent. The medical examiner said, inconsistent with a connection with a motor vehicle. The thing that killed him was the head injury. And the head injury was caused by a fall. And the fall, as the brain surgeon, Dr. Wolf, said, he'd seen loads of people with similar fractures who fell when they were drunk or slipped in the snow. You don't have to be hit by a vehicle to fall and fracture your skull. believe it or not, are just a regular fall. That's why, please learn how to break fall. Make it muscle memory that you never have your head connecting with any surface at any speed. Learn how to break fall. But come on, this is insane. This is absolute insanity. It's insanity. Yeah, so the spoiler hit him in the eye. Yeah. Yeah. So how did his hat not fly off? Yeah, classic blunt head injury, Wolf said. Exactly. Yeah, his hat didn't even come off. Because his hat was found, I don't know, maybe they're saying his hat flew off when his eye connected with the top spoiler. So if we look, let's get that right. So this is a good shot. Right, look. So where's his eye? His eye's here. Where's the top of this thing? There. So he's a little bit shorter than John, like by about half an inch. So how is his right eye going to connect with the top of this vehicle? How? Because you've already got your connection there. So you've already connected, and then you've rolled around to get the cut on your top of your arm. How does it hit your hip? Because your hip's there. Because you're already rolling around. Like you're already rolling around. Look. So there's no connection with your head whatsoever. This is his own experiment, people. And his hip is right the ways round here. So there's no other connection other than the arm. Well, is that because he's made this up? That he has rolled on purpose? Yes, he's rolled on purpose. He's rolled on purpose. This is a true crash test dummy. This is a true crash test dummy because he obviously thinks we're stupid. He leaned into that fall. He leaned into that. He leaned into it. Watch him. Watch him. Connection. He's already leaning. He's already leaning. There's no way his hip could have connected. There's no way his eye could have connected. And got those injuries at the same time. And brought the taillight into 47 pieces. No chance. I'm sorry. It's not happened. The timeline doesn't work. The injuries are completely inconsistent with a 24-mile-an-hour collision. Completely inconsistent. No, it did not happen. Did not happen. Anyway, I'm going to go now and get something to eat. We got a whiles to wait yet. So court should be starting in about 3/4 of an hour, but as she's only starting at 10, then we've got a ways to wait. He thinks he's helping. Well, he's helping himself. He's helping his pocket. He's done what Brennan asked him to do. He's a hired hand. He's a hired gun, whatever you want to say. And he's completely fallen flat. Like the objections that quite rightly Alessi made and the sustaining of those objections quite rightly by Bev. She did a lot of good decisions yesterday. Except that last one when she let him carry on, because Alessi objected and she let him carry on, and then he started splurting the nonsense about DNA. And now we're in the situation that we're in, where his testimony is a complete crock. The jury heard it, and now she has to go away and sleep on it to decide what she's going to do and how she's going to be able to rectify this for the Commonwealth. So, what you got to say? So, we've got Bev making a decision first thing this morning, and then we've got the rest of the testimony, and then we've got cross-examination. So, I will be back tomorrow. Hopefully, I'll be able to focus either on Bev doing the right thing and completely striking this guy's testimony, because that's what needs to happen. But you see, the jury's already heard it, so there's that. But striking this guy's testimony, and that will then end the Commonwealth's case, because there'll be no cross-examination, because his entire testimony struck, so he's gone. And then I assume that this is the last witness. I assume that this is supposed to be the gotcha moment, which fell completely flat for Brennan. Maybe Brev will help him bring it back today. And if so, and he carries on as if nothing happened, then I'll be back tomorrow to talk about Alessi's cross-examination. All right, I'm out of here. Thank you all for joining me. Thanks as always to the mods. And I'll see you very soon. I've already done a video over on Michelle After Dark. There's some stuff there about the remains that have been found in Nova Scotia. Hopefully it's Justin McDonald. It's looking pretty likely that it is. I think his family are hoping it is, just for closure. There's 3 guys in jail already. 1 for manslaughter, 2 for second-degree murder. But they need Justin home. So hopefully the remains are his. And then the rest of the video is about Lillian Jack. So, all right, guys. I shall see you later on. Yeah, she won't strike it. All right. Bye, guys.